Can AI-generated content be a derivative work under existing IP law? Imagine a world where computers create art, music, and stories all on their own. Now, ask yourself, who owns that content? Is it the person who gave the prompt or the machine that made it? This question is at the heart of current debates about intellectual property rights in the digital age. A derivative work is a new creation based on an existing one. Think of a translation, a remix, or an adaptation. Under U.S. copyright law, the owner of the original work has exclusive rights to make or authorize derivative works. For a work to be considered a derivative, it must incorporate recognizable or substantial parts of the original. When it comes to artificial intelligence, things get tricky. AI-generated content includes text, images, music, and more, created by machines trained on large datasets. These datasets often contain copyrighted material. Usually, a human provides a prompt, and the AI produces a result. But does that mean the output is a derivative of the training data? Current laws say that copyright protection is only for works created by humans. If an AI makes something without significant human input, it cannot be copyrighted. This means that purely machine-made content is not protected by copyright law. However, if a person significantly edits or adds original ideas to the AI's output, that new work might qualify for copyright. In that case, only the human's contributions are protected, not the machine's creation. The core issue is whether AI output is a derivative of the copyrighted material used in training. If the AI's output closely resembles or copies protected parts of the training data, it could be seen as a derivative work. But most AI systems generate new, unique content based on learned patterns, not direct copies. Legal experts are still debating whether training an AI on copyrighted works or the results it produces counts as creating a derivative work. Some argue that the process is transformative and does not infringe. Others believe that using copyrighted material in training could violate rights. In practice, whether AI-generated content is a derivative depends on the specifics. If the output is very similar to a copyrighted work, there might be a case for it being a derivative. If it is original and does not directly copy protected parts, it is less likely to be considered one. Content creators and tech companies need to be aware of these issues. Using AI to remix or adapt existing works could raise legal questions if the original is recognizable. But using AI to help create new, original content with human oversight is less risky. As AI technology advances, laws may change to better address these questions. For now, the law emphasizes human creativity and original expression. Whether AI-generated content is a derivative work depends on how much human input there is, the nature of the output, and its relationship to the training data. So, the ownership of AI-created content remains a complex and evolving area in intellectual property law.